Mr. Willie. Mr. Doherty.
Here.
Mr. Matthews. Mr. Davis. Mr. Manila. Mr. Drum. Mr. Randolph.
We have a quorum,
We have,
right?
yes.
Okay, thank you. Public announcement, phones and pagers, please turn them off, put them on silent. If you disagree with anything this commission votes on, you have the right to appeal it to the full council. If you wish to speak on any item, speaker cards are on the railing over here to my right. The same thing is true on appeals. You need to fill one of those out and get it into staff. Each side will have 10 minutes to speak on each item on the agenda if they wish, and then there'll be a 5-minute rebuttal. After your item is heard, if you have a group with you and you want to discuss it, please don't go out in the lobby because that sound still comes back into the building. Please rise for the invocation by Mr. Randolph and the Pledge of Allegiance by Mr. Richard.
Gracious Father, once again, we thank you, Lord, for all the blessings you bestowed in our lives. Thank you for allowing us to experience, Lord, the inclement weather conditions last night, but you graced us with the beautiful, gorgeous weather this day. And Lord, we thank you for every commissioner here. We thank you for all the citizens that we represent and serve. And all these blessings we ask in your Son, Jesus' name. Amen.
All right, the next item on the agenda is approval of the September 9th meetings, which was in your packet. If there weren't any changes or corrections that needed to be made, I'll accept a motion to approve.
So move.
Moved by Mr. Randolph, seconded by Mr. Lauren. Please vote. Motion carries. Thank you. All right, consent calendar. Any items not pulled from the consent calendar are automatically dispensed by vote as approved or as per staff comments. Items pulled from the consent calendar shall be discussed and voted upon individually. Staff, do we have any items that need to be pulled?
Yes, sir, we do. On the first page, under minor subdivision, the first item, MS 1409-052, and on the second page, MS 1409-053, the second item under minor subdivision, both need to be pulled for the commission to consider waivers.
Okay, thank you. Any of the commissioners have any items that need to be pulled? I'll accept a motion to approve the items not pulled. We have a motion by Mr. Davis, seconded by? Seconded by Mr. Randolph. Please vote. Motion carries. Thank you. All right, on page 1, MS 14-09-052, a portion of Lot 4 undesignated into lots A, B, and C, Ward 1, District 1. The owner is Carolyn Chatelet Graham. Surveyor is L&S Land Surveying, LLC. Parish Council District Representative is Honorable Marty Dean. Staff?
Thank you, Mr. Chairman. The owner is proposing, well, the reason why we're having a public hearing for this is the proposed parcel B, you refer to your survey behind the staff report, does not meet the minimum of road frontage width requirement in the zoning of 150 foot. The owner is proposing to create 3 parcels from 1 parcel. However, proposed parcel B, as indicated, does not meet the minimum lot frontage requirement of 150 feet for an A2 suburban zoning district, which would require a waiver of the regulations by the commission. The staff has no objections to the proposed minor subdivision request and supports a waiver for the lot frontage in question due to the following facts. A, the frontage is less than 10 feet from meeting the lot width requirements. B, the lot opens up into a 300-foot width and more, approximately 290 feet back from the roadway frontage. And C, the parcel is a large parcel consisting of 13.15 acres. Since a waiver of the regulations are required in order to approve this minor subdivision request relative to the lot width issue, a two-thirds majority vote of the full membership of the commission, which is 8 members, is needed to approve pursuant to section 40-100, waiver of regulations of subdivision ordinance 499.
All right, thank you. Is anyone here in the audience that wishes to speak on this item?
I mean, we're here, but he said everything.
He covered it quite well, didn't he? All right, anyone else? I'll close the floor to the public, bring it back to the commission. Ms. Casabon.
Yes, this is acceptable because of what Ron had stated, but because she also has the portion in the corner that she has a right-of-way across from A, that is also her property. I'll make a motion to approve.
We have a motion by Ms. Casabon to approve, seconded by Mr. Willie. Any further discussion? We have a motion and a second to approve. Please vote.
With the waiver, excuse me,
With the waiver.
with the waiver.
Okay.
Thank you.
Motion carries. Thank you. All right, page 2.
I'm sorry, Mr. Dowd, I saw the vote was 9-0. Okay, I just want to make sure we got at least 8. Thank you.
Yeah, okay. All right, next item on page 2 is MS 14-09-053, partial B, a partial within an existing minor subdivision in the parcels B1, B2, Ward 2, District 2. The owner is Colleen Baker. The surveyor is LNS Land Surveying LLC. This is in Honorable Dennis Sharp's district. Staff?
Thank you, Mr. Chairman. Again, the reason for this public hearing is parcel B is part of an existing minor subdivision. Any waiver of the minimum lot frontage requirement of 30 feet is required. Is the owner is proposing on parcel B a 25.06-foot frontage, and the minimum requirement stated is 30 feet. The owner is proposing to create 2 parcels from parcel B that is part of an existing minor subdivision. Proposed parcel B does not meet the minimum lot frontage requirement of 30 foot pursuant to code, which would require a waiver of the regulations by the commission. The staff would recommend approval of proposed minor subdivision request if the owner were to simply amend her application by adding an additional 4.94 feet to the frontage of parcel B in order to comply with code. Again, I'm not sure if the applicant has the ability to do this or not, but that is a suggestion and recommendation of the staff. However, if the applicant does not wish to do this, a waiver of the regulations are required in order to approve this minor subdivision request relative to the lot width issue, which requires a 2/3 majority vote of the membership of the commission, which is 8 members, in order to approve pursuant to section 40-100 of subdivision ordinance 499.
Thank you, Mr. Keller. Is Ms. Baker in the audience? Okay, please come to the mic. You heard staff comments, particularly on the additional 4.94 feet of frontage on partial B2.
Yes,
Is that acceptable to you?
it's acceptable if there were a way to get around it. There's an existing fence that I put up for pasture, and it would require me to move the fence 5 feet over to comply with it, but if that's the only way I can do it, then I would be willing to do it.
Okay. All right. Anyone else in the audience wish to speak on this? I'll close the floor to the public, bring it back to the commission. Mr. Willie.
I guess a question of staff there. Would you be required to remove the fence if she extended the width to 4.94 feet? I don't know how the ownership is on those parcels.
There's nothing in the code that deals with encroachments on rights of way, but it is a right of passage, but it depends on where that fence is. If there's enough room to allow for two-way traffic, which typically is at least 16 to 20 feet, then I don't see any problem with them maintaining that in that servitude. Mike, do you have any issues with that?
Yeah, I guess, let me ask petitioner then. Is the fence along that border where you have it proposed with the 25-foot?
It's right on.
So there would be enough room for right of passage for 2 vehicles or a bus or whatever if the fence were to remain?
Yes,
And just to be clear, it's not technically, it's actually part of the property. It's meant to serve as the servitude, but it's not expressly stated as a servitude. It's actually part of their property that's gonna be used for access purposes.
Okay, is that, both properties are gonna remain in your family or whatever? I don't know if you're selling a piece or
I'd like to possibly sell the piece at a later date.
the fence would probably have to be moved in, you know, based on new owners or something. I don't know. Correct, Ron?
Yeah, I think eventually, if they sold it, that fence issue would become an issue at that point, but it wouldn't be an issue for us.
I'd rather see that, you comply with the ordinance, the 30 feet.
And just go ahead and, okay, because when the surveyors came, they did do 2 flags, one at the existing fence line and then another one at the 30-foot.
Okay. Well, if it's acceptable to you, I'd move to approve.
Okay.
Okay, we have a,
I'll second it, but you understand, you don't have to move this fence.
I don't,
just
unless I
if-
sell it,
Unless you sell it.
correct.
I'll second it then.
okay, we have a motion by Mr. Willie, a seconded by Ms. Casabon. Any further discussion? Please vote. Motion carries with a 9-0, vote. All right. Next item, on page 2, preliminary subdivision review, SD-14-09-005P, Simpson Farms, Ward 3, District 3, is developer owners Prudent Creek Partners LLC. The engineer is Kelly McHugh and Associates. Parish Council District Representative is Honorable Red Thompson. This was postponed from the September 9th meeting. Staff?
The preliminary plans and hydrologic study have been
You-
reviewed by this office.
Jay, you're not, that's not on. Is there a switch?
Can you hear me now? All right, there we go. The preliminary plans and hydrologic study have been reviewed by this office, and inspection was made of the site. It is recommended that preliminary submittal be approved, subject to the following. On the plat, note needed, fill credit for each lot is 1,500 cubic feet. Revise restrictive covenant number 10 from 35 feet to 60 feet. Drainage comments, the 25% reduction requirement includes the green space area. Show that the flow reduction for the entire subdivision acreage is reduced to 75% of pre-development peak flow. The lift station should be raised to prevent floodwater infiltration. And there's also a verbal addendum. Culvert and storm drains shall be installed in accordance with section 40-032.03 subsection 8. For traffic, this development was reviewed as a PUD and was approved by the zoning commission. Therefore, pursuant to the PUD ordinance, a tentative subdivision hearing was not required. Therefore, the TIA has been reviewed as part of the preliminary review. The TIA shows that all affected intersections operate at a level of service D or above, with the exception of the intersection of US 190 at Pruden Road. The study shows that the southbound approach of this intersection falls to level of service E once this development is in place. In order to bring the level of service back up to D, the addition of a right turn lane is needed on Pruden Road southbound, turning onto US 190. Per the traffic impact analysis ordinance, the construction of this turn lane is the sole responsibility of the developer, including all right-of-way costs, mandatory impact fees, and a DOTD driveway permit. However, the relative impact of this development is under review by the parish, and a development agreement for infrastructure improvements may be needed. A funded maintenance obligation in the amount of $10,000 is required in accordance with subdivision ordinance 499, section 40.061.08, funded letter of credit for existing parish roads to ensure the repair of any damage to the parish roads resulting from construction in connection with the subdivision. Mandatory developmental fees are required at final submittal in accordance with ordinance number 04-0990, since a public hearing was not held prior to January 1st, 2005. Department of Environmental Services has comments.
Plans and specification for the construction of Pruden Creek water system and sewer system has not yet been approved by the Department of Health and Hospitals as required. Revised plans and permit applications showing additional capacity for these systems must be submitted for review. Plans and specification for the construction of the project's water lines and sewer collection lines have not yet been approved by the Department of Health and Hospitals as required. No work order will be issued until the submitted plans and specifications are approved by DHH. Development has the following comments.
A preliminary draft copy of the Declaration of Covenants and Restrictions should be remitted to this department for review prior to development receiving a work order in conjunction with the preliminary subdivision approval process. 2, the developer has depicted green space and amenities within the development pursuant to said parish code requirements. Therefore, the developer should present to the Department of Development a recreational development plan in conjunction with the submission of a preliminary subdivision review application. In this case, before a work order is to be issued, we need to get a copy of that plan for review. And also that plan should include the amenities that are being provided, a site plan and/or landscape plan if applicable, a time schedule for development, and the entity or entities whom shall be responsible for the liability and maintenance of the recreation and/or green space areas. Staff recommends approval subject to meeting these comments.
Thank you. Mr. Maroon.
Thank you, Mr. Doherty. Members of the commission, Paul Maroon on behalf of Prudent Creek Partners LLC, which is the developer of Simpson Farms, to walk through some of the staff comments. With regards to the engineering comments, in particular, the items on the plat, we'll have those items corrected. We had made an amended submittal not too long ago. These are some additional clarifications and corrections that we'll make, so we'll have that done rather quickly and sent in. The lift station elevation is identified under Section B, has been made on the plan, so that has been corrected. In regards to the traffic study and the need for the turning lane, we are in the process of working with Mr. Fontenot and the administration on a potential developmental agreement for that improvement. It's somewhat of a unique situation in that this development does not create the problem. In fact, that intersection will need that turning lane through the natural growth in the area, which is a fixed component of the traffic study even without us. But we are, if you will, the straw that kind of broke the camel's back, and so we are going to be a part of that improvement. And we're in the process of working with the administration to determine, so that they can determine what is the best and most efficient way to get that done. And we'll continue to work toward that resolution. And once that's done, then of course there'll be a firm agreement in place that will dictate when the turning lane will be constructed, how it will be constructed, who will construct it, and the funding mechanism. So all of that will be done before the work order is issued. The other items in the staff's report we're happy to comply with, including the plans and specifications for the sewer and water system. If we're fortunate enough to receive approval this evening, then we'll be in a position to submit those on to DHH for their approval. The restrictive covenants and the recreational plan, we'll be happy to provide those to Mr. Keller. You may recall, as part of our amended PUD, we agreed to increase the number and types of some of the amenities that we have, including a walking path. You may recall that we're going to have a clubhouse with a pavilion area and other playground equipment and so forth in the large recreational area that we have near the center of the development. So we'll detail all that, and we'll have that to Mr. Keller before we seek our work order. With that said, we would respectfully request your approval of preliminary, subject to the staff's comments, and to having each of these items worked out and resolved prior to pulling the work order.
Thank you, Mr. Morone. Anyone else in the audience wish to speak on this item? I'll close the floor to the public, bring it back to the commissioner. Ms. Casabon.
Yes, Paul, on the water and sewerage, where will that tie in?
We will tie into the new system that is being constructed at Prudent Creek, just down Pin Mill Road. Okay. There'll be a well and a sewer treatment facility there. We'll tie directly into that.
Okay, it's independent of the lakes of Pin Mill?
It is completely independent,
okay,
yes, ma'am.
On that, and it's below the savanna, so that was
yes,
one of my
ma'am.
questions too. The preserve is there. That answers my questions. Anybody else have any questions? I'll
Okay,
make
Mr. Davis?
Yes, Paul, looking at the plat, you have 3 retention ponds on the property, correct?
Let me get to the plat. I believe that's correct, yes.
Okay, so all 3 retention ponds will be built in phase 1? because you have drainage on the drainage plan going to the rear.
It's a ditch.
And I have concerns also, why isn't the clubhouse, picnic area, and active recreation in phase one as well? You have 69 lots in phase one and only 37 in phase two, so
Right.
I don't understand why you would wait to put, the clubhouse, picnic area, and active recreation in phase one as well.
Well, and I'll start with the second question, because that one's a little bit easier for me to answer without looking at the drainage plan on the ponds. But the reason that we would put the recreation in as part of phase two is that if we put it in as part of phase one, then all we would have out there at that point is streets, utilities, and the recreational facilities. We don't yet have the homes and the residents that ultimately will be the caretakers of that. And in past instances, what we have found is that if we get those type facilities out there before there are residents to keep an eye on it, then we end up having problems with security and vandalism of those items. So what would happen is the infrastructure would go in as part of phase one. The home building would commence. If things go according to plan, we would then be rolling into the infrastructure for phase two so that that would be put in with the recreational facilities. So at the time you start to get occupancy in phase one, those facilities would be there.
So you're not relying on the people in the initial phase one, 69 lots to be able to take care of that clubhouse? You're gonna wait for it all to be completely sold out before you build that recreational area in the back? Is that what?
Well, we're not necessarily waiting for all of the homes in phase one to be built out. But we are looking to complete all of the infrastructure in phase one and be in a position to sell the lots in phase one to homeowners and to builders so that we have residents out there by the time we complete our recreational facilities.
You have 4 small green space areas in phase one now.
That is,
By in between 104 and 105, right next to 106, on the outsides of 5, 6, and 7, and by 91, lot 91. What basically are you gonna have there as far as for the 69 home individuals?
well, those spaces that you mentioned is the 1 by 5 and 6. The interior walking path, if you will, between 38 and 39 on up. Those are not going to have recreational facilities other than the walking path.
Okay.
All of the facilities will be located around the clubhouse area, which is just north of those items.
So if this development doesn't build out quick enough, could there be a possibility where that phase two never be built?
Well, I guess there's always a possibility that phase two would not be built. Although, as you can see, the vast majority of the lots are going to be in phase one.
You're right.
So, we're front-loading a good bit of the infrastructure onto phase one. So to complete phase two at that point would not be, a very monumental task. I mean, we would merely be finishing up. So I think that the likelihood of not building out phase two would be pretty slim.
Okay, and my second question about the retention ponds in the
Yeah.
back, because you do have drainage going to the back, starting at, I believe, around lot 98 going back. So half of that phase one is gonna be draining to the back. So those retention ponds will not be built until phase two, is what you're saying?
No, we're definitely gonna have one of those northern ponds in, and it may be both, because you're absolutely correct. The drainage along Turf Drive, 98, 97, those lots, it is flowing back to those ponds. So we'll have at least one of those, if not both of those, in as part of phase one, so that we can make sure and accommodate all the drainage that's coming from phase one.
Yeah, because I can see you have flood zone C goes through the middle of the phase one, and you got flood zone B on the other side, so obviously it's gonna probably try to tend to lead that way.
Right. I think that there is a break point there where it is falling toward that ditch that is out there.
Okay, thank you.
All right, we have any further discussion?
I make a motion to approve.
Okay, Ms. Casabon, a motion?
Do we have any opposition? Did you ask for opposition?
All right,
Okay.
Paul, let's see what these folks have to say. Please come forward and state your name.
David DePaul.
And Claire DePaul.
Okay,
And our concern more is with Phase 2. So I don't know if this is the appropriate time to bring this up, but we're more concerned about the buffer zone and the green space on the north part of Phase 2, which borders our property. And we would like a fence and so forth and things there. And we're just finding out, this is our first time seeing this plan, was 2 days ago.
okay. What is your concern?
It borders our land, and
Okay.
we just wanted to have a buffer there, so they just not right out on our property. They would open up into we have 160 acres there. And
Okay.
so,
We're the property owner to the north, so this lot 70
So-
through 78
which is
would butt our property
right on
line.
right on onto our land.
Right, it's right on top of
So,
our property line,
What-
is our concern.
Our other side of the property line is Penn Mill Lakes, if you're familiar with Penn Mill Lakes, that's our other side.
Okay.
And when they did that development, they gave us a 100-foot buffer zone, which 50 feet of it is a no-cut zone, and a fence was placed there. And then we put in seedlings and so forth to create a buffer between the developments.
Okay.
And that's kind of what we're looking for on this side, the same thing.
All right.
So, if we could get some green space, like 100 feet, and then 50 feet of it would be no cut, where people couldn't just cut it all down and make their lots bigger.
Okay, well, let me, see if there's anyone else that wishes to speak against approval on this, and then I'll go into rebuttal, and Mr. Morone can address your question at that point in time.
Okay.
Thank you.
Is there anyone else that wishes to speak against this particular item? Paul, let's go into the rebuttal phase, and
Thank you, Mr. Doherty. I guess a couple of comments there. As you're aware, I mean, this project has been around since 2012, and we were back again as recently as June, wherein, this lot layout was established. So as far as trying to create a 100-foot buffer or otherwise modifying the lot layout, we're really beyond that point now. We're not in a position to do that and couldn't do that. However, we have 9 lots that do abut our northern property line, and we don't have any objection whatsoever to requiring that as those lots come into commerce, that there be an opaque fence, wooden opaque fence built along that property line. For each of those lots, we don't have a problem having that in the restrictive covenants and making that a requirement. Other than those lots, they are buffered by a retention pond and then other green space. I would also point out that, to the best of my knowledge, there are no homes or structures within hundreds, 600, 700, maybe 1,000 feet from this property line. So there's not a home right there. There's good buffer there on that side of the line as well. But we have no objection to committing to a fence along the back of these lots. And we'll do that as part of the construction of any homes, and we'll mandate that in our restrictive covenants as an attempt to try to address their concerns and try to give them some sense of security that they won't have people that would be trespassing.
okay, thank you. Yes, ma'am, come back to the mic, please.
The first we heard.
Come back to the mic, please.
We were notified in 2012, like he said, and the set of plans that he gave us in 2012 had an enormous amount of buffer. If y'all want to pass it around and see, it's completely different than the set of plans that we saw yesterday. The Phase 2, you can see maybe from here, it just projected slightly, and all of this was green space and retention. And the green space he talks about is our land, so he's using our land as his green space for there are no future. So one other concern that we have is if we do decide to develop one day, we'll be in front of the board and we'll be having to create that green space on land that we own because his lots are right on our property. So if we did develop, I would certainly put 100 feet. If he put 100 feet, then we'd have 200 feet, and there'd be a lot of green space, and we plant with trees. We planted over 70,000 trees on our land, and I would do the same, so all the subdivisions aren't just, like, I don't want to say some, non-St. Tammany Parish subdivisions. And that's what our concern is. And if you go out there, you'll see between Penn Mill and us, there's about 50 feet on our side and 50 feet on their side that's heavily planted with trees, and that will always remain. And that divides the subdivisions in our eyes.
Okay.
So we're, you know,
Fence is
we
not
have,
gonna stop somebody from
and
walking
plus
around
future
it.
development. Like if we come back and develop houses, then our house is right up against his houses, then we end up with these back-to-back subdivisions, you know,
Yeah.
like,
I'm
non-
guessing right now, that probably the drawing that you're looking at was in preliminary. Paul, does that sound,
this is something.
That was probably the original.
I'm sorry,
It's
tentative?
dated 2012,
That was tentative, right?
and this is the last we had heard. That-
original PUD layout in 2012.
Right, which has a whole lot more green space than what's here.
Okay, and that was probably approved by this board, and now that it's been modified, which our ordinance would certainly allow the modification. Okay, now, you know, Mr. Morone has indicated that they will put a wood fence along four or five lots, I forgot now,
9 lots.
nine
Maybe
lots.
nine.
It still doesn't fence off the
Right.
retention pond from our property also. I mean, somebody could just walk around the
Right.
fence at the retention pond onto our property. I mean, it doesn't,
Well, I'm not gonna sit here and tell you that will not happen, okay? But by the same token, they'll be walking on private property. And it'd be your, call to whether you get the sheriff out there and have them arrested for
we
trespassing or
just don't
something
want
like
to get
that.
to that point. We'd rather just
And then
avoid that.
if we ever came back and developed it, and we wanted the lots to go right up to the property line, like he's having them go to the property line, will we then have a problem?
Well, that's another one of those what-if things. I mean,
Right, right.
And we can't deal with the what-if right now. So we've
We
got-
just feel it's a way different than what it was originally proposed. It's changed a lot on our end. That's how we feel.
Okay, thank you.
Okay.
All right. Want to bring it back to the commission now. Mr. Dave, is that your line?
Yes. Just a point of clarification, at this point in time, there is no requirement that requires a buffer, is there? That's the staff?
Ron?
I think when it went up for PUD.
Yeah, under the PUD approval, that's what their plan was revised to indicate what they now have in place.
But that meets all the requirements currently.
Yeah, because you all approved it, yes.
Okay. All right, Mr. Willie.
Just, Ron. Ron, just to ease these citizens' mind here, they were proposed, the first proposal they were showing me with a lot of green space, that was a tentative proposal, right? And then there was a public hearing when we voted on this PUD.
Right, when was the public hearing on the revised PUD?
The revised PUD was heard in June of this year.
Right. Okay, and that's probably a meeting y'all missed, it sounded like to me.
And that was, the green space is by and large the same as an overall component of the project. The lots did shift as a result of some wetlands and avoiding some of those wetlands in the property.
Okay, I'm just trying to give them an explanation why it was changed, and it was at a public meeting when it was changed. So,
Okay. Any further discussion by the commission? I'm looking for a motion.
Earlier.
Ms. Casabon, you made motion to approve?
Yes, sir.
Okay, Mr. Willie, a second. Any further discussion? Please vote. We have a vote of 8-1, 8 yea, 1 nay. Motion carries. Thank you. All right. Next item is final subdivision review, SD 10-06-004 FIIC The Village of Normandy Oaks, Phase 2C, Ward 1, District 1. Developer owner is Allstate Financial Company. The engineer is John E. Bono and Associates. This is in Parish Council District Representative Marty Dean. Staff?
Periodic inspections have been made by this office during construction, and the final inspection was made on October 2nd, 2014. The inspection disclosed that all asphalt roads are constructed, road shoulders are constructed, and the roadside swells and subsurface drainage are functioning. The following minor uncompleted items existed at the time of final inspection and will be completed before the plats are signed. Items A through D are okay. Need surveyor's stamp on plat, need developer's signature on plat. Both roadway cross-sections need to be legible and have correct dimensions on the plat. The drainage as-built we received today is okay. Need benchmark and geoid used on plat. Items I through K are okay. Items L, required street name sign is improperly located. We'll look at that when at the warranty release inspection. As-built signage plans need to display the following information. The distance between the edge of the shoulder and the edge of all signs is 2 feet. The distance from the edge of the roadway and the underside of all signs is not less than 7 feet. Add the following notes to the signage plan. All signage shall be type 3 high-intensity retro-reflective in accordance with MUTCD guidelines. All signage shall conform to all MUTCD and parish requirements. A copy of parish requirements can be obtained from the St. Tammany Parish Traffic Engineer. Street name signs must be yellow lettering on blue background. Should the Planning Commission approve the request for final approval, a warranty obligation will be required for the infrastructure in the amount of 892 linear feet at $12 per linear foot, with a total of $10,700 for a period of 1 year. The staff recommends approval of the proposed final subdivision request, subject to the developer complying with all comments and no plats to be signed until all items are satisfactorily completed. No mandatory developmental fees are required since the developer has an existing voluntary developmental agreement for Normandy Oaks subdivisions. The Department of Environmental Services has no comments. They've all been addressed. And planning has no comments either.
All right, thank you. Mr. Marone.
Thank you, Mr. Daugherty. Paul Marone again on behalf of Allstate Financial Company. To the best of my knowledge, even the few items that remained outstanding, such as the surveyor's stamp and the developer's signature on the plat, were accomplished today. Spoke with Mr. Weiner this afternoon. He was with the surveyor signing the plats, and those should have been delivered later in the day today. All of the other items, according to the engineer, have been addressed, and all of the infrastructure is in. So we would respectfully request your approval, excuse me, subject to your staff making sure that in fact each of these items have been submitted as required in their comments.
Okay, thank you. Anyone in the audience wish to speak on this item? Yes, sir.
My name is Dan Jeremy, and I'm here representing the Homeowners Association for Normandy Oaks, which is the subdivision that's right adjacent to the new development. And I have two concerns that I've been asked to bring forward. One is that now that all the streets are completed in the back, we'd like to request that construction traffic be diverted onto those back streets now instead of through our subdivision, because they've created quite a hazard for our citizens. And then the second question is concerning the street signs. We're in the process of trying to replace our street signs, which are wooden and don't meet any of the requirements. We've noticed that the new section, the villages, their street signs are black and white. And we want to know what color we should replace ours. We've been waiting and waiting, and, you know, we'd just like to know how to go forward.
Jay, I'm going to refer that to you, but I think it's yellow lettering with blue background.
Correct. As of right now, our ordinance stands for parish maintained roads. They have to have yellow lettering with blue background. Private roads are white lettering with green backgrounds. The parish is right now revising that ordinance, but it has not been adopted yet. So as of right now, it's those color combos that I just said.
Does that answer your question?
It does. We just want to comply with the parish, but we also want to, you know, the same as the villages. So if we're all the same, then we don't have a problem with that. But we don't want to buy the yellow and blue signs and then have black and white in the back.
Well, I can tell you right now, the white lettering on black background does not meet MUTCD, so those will not be allowed. Those will change. So they have to meet MUTCD, and like I said, the parish is going through a new ordinance for that. And I guess right now what we're telling all the other subdivisions looking to change signage is just hold out until we have a definite answer for you.
Okay. Thank you.
Okay, and Paul, you want to address the gentleman's first question?
Yes, I will certainly be glad to talk with Mr. Weiner about the construction traffic as part of this new phase, and make sure that he gets in touch with Mr. Jeremy so that we can work that out. I feel certain that we can address his concerns.
Okay. I do need the speaker card filled out for you, sir, and turned in. Did that answer your question?
Yes, it did. Thank you.
Okay. All right. Anyone else in the audience wish to speak on this? I'll close the floor to the public, bring it back to the commission. Pug.
I have one question. As regards to the street signs, the rules you were speaking about just a few minutes ago has to do with public streets, is that correct?
Yes, parish maintained streets are yellow lettering with blue backgrounds, and private maintained streets
The
are.
reason I ask is there's a
white
lot
green.
of private subdivisions that have got very ornate wooden carved signs and that sort of, and that doesn't apply to those, does it?
The new ordinance might take that into account and give them a certain time frame to get these in accordance to MUTCD regulations and requirements. So like I said, it's still in the air right now. We're trying to work out everything, but it is coming. So, but as of right now, we can only do what the ordinance calls for, and that is, that was established back in '99, and it's, the private roads and public roads have certain color combos.
But again, subdivisions like Beauchene
Right. Or even Normandy Oaks.
or Normandy Oaks that
Right.
have the wooden signs,
Correct.
they're still free to replace or maintain those the way they are, aren't they?
Well, they're in the parish right away. That's a technical
No,
question
no.
that would,
No, not
legal
if-
should do it.
Beauchene's not in the private right.
Well, that's a private, so then they could take care of it
That's my point.
their own
If
way.
it's
But
a
Normandy
private-
Oaks is a parish
It's
maintained
public.
road that is public right of way. So those signs are in public right of way and actually been taken into the maintenance system. So the HOA for those subdivisions that have ordinate signage out there that are on public streets, they're not allowed to, no, sir.
I don't have any disagreement with that. My question is, the private subdivisions, and we got a lot of them in the parish.
Yeah, private subdivisions, that's their streets. We don't go into them and maintain
They
them.
can do what they want.
Well, the ordinance is going to, the ordinance now says they have to have white lettering with green background. Technically, like I said, that's probably going to be a legal question. It's above my pay grade, tech.
All right, do we have any further discussion by the commissioners? We need a motion to approve.
I move to approve.
Mr. Richard, motion to approve, seconded by Mr. Davis. Any further discussion? Please vote. Motion carries 9-0. Thank you. On page 3, Mr. Shane, you had something you wanted to be recognized on? Uh-huh.
I'd be happy to take it after the other items if you'd like.
Okay.
That'd be all right? So
That's
we can-
fine.
For those that are in the audience.
Okay. Old business on page 3. First item is SD 06-08-027, F3, Rayford Oaks, Ward 1, District 1. Developer owner Rayford Oaks LLC. Engineer is Scalfano Engineering. This is in Honorable Marty Dean's district. This is request by developer to amend the location of a drainage servitude. Staff?
Thank you, Mr. Chairman. DSLD Homes LLC is the owner of lots 109, 110, and 111 in Rayford Oaks subdivision, Phase 3. If you refer to the survey plat that's attached to the back of the documentation, you'll see the lots in question. It's a simple request for them to relocate a 20-foot wide drainage servitude, which was currently on the common lot lines of 110 and 111. They simply want to move it southward to where it'll be in common, the 20-foot servitude in common with lots 110 and 109. There are no objections by the engineer department for this request, and because it does involve a modification of a final subdivision plat, it does require the public hearing for the commissions to review and consideration. They have submitted, which is part of the process, if the commission decides to approve the request, they have submitted an act of correction which will be filed in the courthouse public records signifying the change of the location of the servitude.
Okay. Thank you. Is anyone here representing this item? Yes, sir. Come forward, please. State your name and fill out a speaker card.
Toby Eastley is with DSLD. We're actually the owners of the lots that are affected.
Okay. And you're you approve the changes?
Yeah, we approve. I mean, it was just a mistake on the surveyor's part during the final plat approval process. So we just need to move it to where the pipes actually are to make sure it's in the servitude.
Okay. All right. Please fill out a speaker card. So the drainage is already in, and where we're just doing this after the fact. Is that what I'm understanding?
Yes, sir.
Okay.
So the petitioner owns owns lot 109, 110, and 111?
I'm sorry?
You own all 3 lots or 4 lots in there?
Yes, sir.
Okay.
Yes, I do.
Okay, Ms. Caswell?
Yes, this is an act of correction, and like you said, after the thought, I'll make a motion to approve.
I'll second.
We have a motion by Ms. Castlebaum, seconded by Mr. Willie. Mr. Richard, you had a comment? Any further discussion? Please vote. Motion carries 9-0. Next item's MS 14-07-045, a 10.0 acre parcel into parcels A, B, and C, Ward 5, District 6. The owner is John Haygoods. The surveyor is John G. Cummings and Associates. This is in Honorable Richard Tanner's council district. This is a request by the owner to amend his minor subdivision survey plat. Staff?
Thank you, Mr. Chairman. The owner wishes to amend his original minor subdivision survey plat by reconfiguring his 3 proposed lots so that 2 of the lots will have public road frontage, with the 3rd lot having access to a private drive. You can see a copy of your revised survey attached to your staff report, thereby relieving the owner from having to construct the private drive to a parish standard pursuant to the regulations. If the commission remembers, he appeared before the commission last month, determined that the roadway was onerous for him to construct to parish standards, and therefore the reason for the revision. The staff has no objection to the proposed minor subdivision request, subject to the condition that was established at last month's meeting, which requires the owner to allow access to his property by the parish for purpose of widening Honeysuckle Road in order to enhance traffic safety.
Thank you. Mr. Haygood, I see you in the audience here. Do you have any comments you wish to make to the commission? Okay. I'll close the floor to the public, bring it back to the commission. Mr. Willie.
I move for approval.
Motion by Mr. Willie to approve, seconded by Mr. Davis. Any further discussion? Please vote. Motion carries 9-0. All right, next item is SD 08-06-008, P as in Paul, B as in boy, P as in Paul, Tammany Business Park, Ward 7 and 9, Districts 7 and 11. The developer owner is Redco. Engineers Kelly McHugh and Associates, Parish Council District Representatives, Honorable Jacob Groby and Steve Stefansek. This is a request by developer to waive the $15,000 maintenance obligation. Staff?
This is a request by the developer to waive the $15,000 maintenance obligation. Due to the streets for Tammany Way and Provision Landing that is in Tammany Phase 1 subdivision, they are not in the maintenance system yet. They are dedicated to, but they have to be constructed and then taken in after their warranty period. So we have no objections to waiving this because they're not in the maintenance system yet. It needs to go up to vote for y'all. I believe it's going to be a 2/3 vote as well for a waiver. I don't know, Mike, maybe you can help us out with that. But there's no objection from engineering.
Okay, thank you. Mr. Shane?
Good evening. Jeff Shane, I represent Redco, the developer of Tammany Business Park, and echo, I guess, the comments made by staff. When we procured preliminary subdivision approval in August, quite frankly, I think it was probably an oversight by all that this particular requirement was put in place. Typically, the imposition of a maintenance obligation would presuppose that the road has already been constructed and dedicated, and you would want to safeguard the public interest in the event the developer, in the course of constructing the development, obviously created harm to the road. These roads have not yet been completed. They're currently under construction. Once they are constructed, obviously, they're going to be dedicated. There's going to be a warranty bond. They're going to eventually go into the system. I think that's why once the matter was brought to staff's attention, they recognized that the need for a maintenance bond did not appear to be present under the current circumstances. So we would respectfully ask that you grant the waiver and consider, I guess, amending the preliminary subdivision approval by removing this particular requirement so that no $15,000 maintenance obligation be placed at this time.
Thank you, Mr. Shane.
And I have a card if you need one. I don't know.
Okay, all right. Anyone else in the audience wish to speak on this item? I'll close the floor to the public, bring it back to the commission. Ms. Casabon?
Yes, the staff has no problem with this. I'll make a motion to approve the rescinding of the $15,000 maintenance bond.
All right, we have a motion by Ms. Casabon, seconded by Mr. Lauren. Any further discussion? Please vote. Motion carries 9-0, so that hits the 2/3. All right, under old business, Mr. Shane has an item he would like to discuss with the commission.
Point of call.
Yes, sir.
I thought we're finished old business.
Pardon?
Oh, aren't we finished old business? There's nothing written on our agenda about this.
We will probably have to have a motion to open the agenda to allow any discussion or anyone to come forward and speak.
Well, I think that the commission rules allow for discussion of items not on the agenda. However, and so discussion would be allowable if the chairman so allows it. However, if following that discussion, there requires some commission action, then there would be a vote necessary for that. And should it be the case, I perhaps can be more, give more explanation on what would be the proper procedure, assuming there is one, following that discussion.
Okay.
Again, to the point of order, if the discussion is informational only to provide, however, given that we're a public body and given that we send out an agenda for the public to see, if the discussion has anything to do with any aspect of controversy or any aspect of opposition, I would counsel this commission strongly to stop the discussion. We're a public body. If it's information only, then I think we would listen. However, if at any point in time there would be a point of opposition that would come from the public regarding its matter, I do not feel that the commission should address it.
Okay, thank you, Mr. Manella. Based on the comments, Mr. Shane, I believe it's in my authority to allow you to begin speaking, and if there
Yes.
seems to be some opposition to it, then we will cease discussion at that point in time.
Yes, sir, I appreciate that, and I'll certainly be respectful. If I could, because this, I realize, is somewhat out of the ordinary. For the record, my name's Jeff Shane with the Jones Fussell Law Firm, and I actually represent a group of parties that are working with the city of Slidell in order to extend a water line along Lindbergh, which is in the northwest quadrant of I-10 and Fremo in Slidell. Rather than getting too deep into the rhetoric, if you could give me just a few minutes to set the table, and I recognize that you may want to make decisions as it relates to whether you'd like me to continue. But only mid-afternoon, about 3 o'clock today, was this problem brought to my attention, at which time I brought it to the attention of Mr. Keller and Mr. Savant, and I appreciate them taking some time to look at it this afternoon. In my view, it's a fairly simple matter, but let's see how you feel about it. In connection with the extension of the water line along Lindbergh, which is a parish road, my clients properly placed a matter on your docket, and via resolution 12-055 procured permission to enter the public right-of-way to construct the water line. Your ordinances, those resolutions, I think almost without exception, say two things. They give you, the developer, 6 months to get all the documentation into staff, and it also specifically provides that you have 2 years to construct the improvement that you wish to put in place. The good news is that this project, albeit slower than anticipated, is now ready to kick off, and in fact, we hope to put the water line in next Monday. The bad news, if any, is that I'm told that although this resolution has in fact been extended in the past by your commission, the most recent extension expired on August the 11th. Again, we realized that at about 3 o'clock, 2:30 this afternoon. So this is not a matter of first impression to you, not a matter of first impression to the public. The resolution was not only adopted via the consent calendar, but has been extended, I think, maybe as many as 3 times. I wasn't able to get all of the history in the few hours that I had this afternoon. I know that staff is in a position to comment about the history in terms of confirming what's happened in the past, and also to tell you how they feel about us seeking an extension this evening. So it was my idea to make an appeal to you to consider unanimously voting to open the agenda, and then perhaps considering granting an additional extension, as I believe you may have done 2 or 3 times in the past, to allow this water line to be placed in the public right-of-way pursuant to the same exact terms and conditions that you approved initially, with no deviation. So that's simply the matter that I would hope that you might consider under old business this evening.
Thank you, Mr. Shane. I'm going to ask any of the commissioners if you wish to speak on this. Ms. Casabon.
Yes, this seems like a common sense thing that it looks like we missed a date or they missed a date on something, and we have approved this more than once. And it is, to me, the public service. This is something that is needed for the city of Slidell, and it's already in the works. It's not like people do not know that this is coming. It just seems like a technicality to me, and I'll make a motion to open it up, whatever how you word it, to be voted on tonight.
Okay, we have a motion by Ms. Casabon to open the agenda.
Second.
We have a second by Mr. Willie. Mr. Davis.
Yeah, my only point is, Jeff, those past extensions that were granted on this were in the written agenda.
Yes.
Yes, so this wasn't new, I mean, that, and we've done that before, obviously given extensions, but we've never given an extension where it wasn't actually a legal recall, where it was actually placed in the agenda and to address. I'm sorry you guys missed this for the last 2 months, but it just seems like that's your problem, to be honest.
I don't doubt that it's our problem that we missed it.
Yeah,
But I would hope that you might open the agenda so that we can have discussion, particularly in light of the fact that we're talking about extending central sewer and central water.
no,
which-
I understand
But
that.
I'd just like to say, though, that the consequence of allowing this project to go forward sooner rather than later will not only provide for the development of the area, but it also has, I think, significant health and safety ramifications. There are fire hydrants that are being placed at the proper intervals. I mean, we're going to be providing some good services to some people that currently live and/or have businesses in that area by virtue of this project. But make no mistake about it, this is not something that someone on the staff or commission level failed to flag. It's something that we, the development team, failed to keep an eye on. And I don't mind telling you, the reason was simply this, and you've heard this from me and others nearly every month now. We waited 6 months to get DHH approval beyond the date that we anticipated getting DHH approval for the extension of this water line. We blew it because we didn't keep our eye on the ball as it relates to this resolution. Had we gotten, we now have DHH approval, I might add. Had we gotten that DHH approval sooner, as expected, obviously wouldn't be here tonight. So, and we're anxious. We have a contractor prepared to go hopefully as soon as Monday of next week, and that's why we wanted to at least ask you to consider it.
And what would be the consequences of not doing it next week and doing it next month?
Well, there's a couple of consequences. One is that there's a pending sale to a group that's going to purchase or build a mattress firm building, and that sale is supposed to close in about 45 or 50 days. We still have time to get the water line in along Lindbergh if we can start Monday. Obviously, if we can't, the matter has to go onto your November agenda, which I would guess would be somewhere around the 8th, 10th, 11th, 12th of November. So we're going to lose almost a month to the day before we'd even get the approval. And again, if you had not, I think one of the things that's interesting, although it may not be something you've done, if this were a case of first impression, meaning that we had never sought approval, I wouldn't be standing here asking, and you would have asked me to leave, I think, long before now. It seems to me where we know that we have met your parish regulations and we have procured extensions from you in the past, it may be something you would be willing to at least think about tonight.
Yeah, I'm not really concerned about the subject matter. I think I'm more concerned about is it really legally what
Could
what
we
we're
ask
doing here.
counsel?
That's my question.
His opinion?
Well,
I'll get to that, but let's let the discussion go forward right now. Mr. Manella.
And I would echo Mr. Davis's point. It's not, we would believe everything is proceeding accordingly. However, the point that, correct me if I'm wrong, Mr. Shane, but it expired August the 11th?
yes, and I don't know that it's clear what expired on August 11th. Staff may be able to help you, but there are two time periods in the resolution. One time period is for the submission of the necessary documents within 6 months. But the resolution also states that you have an additional 18 months, or a total of 2 years from the time the resolution is adopted to complete the construction. So, again, I was unable to determine this afternoon if the August 11, 2014 date is the tolling of 6 months from the last time the extension was granted, or if it's 2 years from that time. I obviously made the decision mid-afternoon, since I didn't have a hard answer, to at least try to get before you this evening. And I would suggest that if this would provide some comfort, if you would be willing to consider and grant the extension this evening, we would also ask that it be placed on your agenda in November, at which time we would ask that you ratify what you do this evening. It seems to me that that will still require compliance with your typical process, We understand that if someone questions the extension that might be granted this evening, that I will acknowledge that we take that risk, if you will, but it seems to me that is an element to this that could be accomplished, which does respect the integrity of the process that you follow. So I don't think I need to say any more. I think I need to listen.
And that would be my only concern as a procedural, not providing that if for whatever reason there was someone who was in opposition, that could be publicly heard relative to this. The other part I would defer to council. 2 points. Number one, Mike, can we open it and do that without addressing if there is any opposition, number one? And number two, does staff have any authority within it in a case of an emergency not to incur additional cost or potentially negative impact on the public, as Mr. Shane has eloquently stated to us, that they can do something for which the commission then would have to ratify at its next meeting, not unlike some of the public entities we have where emergency provisions can be made, at which time it must go in front of their commission or board, recognizing that there could be a public inconvenience or a cost, an undue cost, whereby they do not see any reason why they would not go forward.
Okay?
I
Mr.
have
Chairman?
one more question, Mr. Davis.
Well, if we're gonna do that, then I need to recognize, Mr. Lauren and Mr. Hines. I believe they had their light on.
All right,
Buck.
well, I think the request is completely reasonable, but my question is, does the staff, I'd like to hear if the staff has any comments.
Okay, well, let's ask, let me see what Mr. Hines has, and then we'll go from there. Mark?
Well, I personally have no problems with it either. And as far as I'm concerned, I would make a motion that it be approved and that it with no expense to the staff whatsoever, in the event that it came up, back up in November, okay, that all expenses would be bared by the petitioners.
Mark, I'm going to stop you right there just a minute. I don't think we're ready right now to accept the motion, okay? Because I wanted, as soon as the commissioners that wish to speak, then I'm going to turn it over to Mr. Savant to give us a legal opinion on this.
Go right ahead.
Okay, Mr. Willie?
What is, when this was first approved, what length of right-of-way did we talking about here anyway?
Along Lindbergh, it's approximately, I believe it's 1,000 to 1,200 feet.
Has it changed? I just want to know, has the right-of-way changed as far as number of driveway cuts into it or anything like that?
No, sir.
Has it changed very much over the first
It has
approval to
not.
now?
No, sir. Well, first of all, the property is now annexed into the city of Slidell, but to answer your question, it has not changed.
Okay, that's what I needed to know.
The plan is the same as it was when we initially got permission from the parish to place the,
Maybe be more concerned citizens if it, it had built out or something.
Okay, Mr. Savant, looking for guidance from you.
Thank you, Mr. Doherty. I was advised before the meeting of some of the general particulars about this situation, and I had an opportunity to do some quick research. And what I'm about to say, I want to stress that I am only making statements regarding to the legal aspects of this request, nothing more. I want to begin by saying that the open meetings law of this state talk about public bodies. And first off, realize that a planning commission is a public body that has to comply with those open meeting laws. Going on from there, state law also goes on to say that, and I'm quoting part of this, upon unanimous approval of the members present at a meeting of a public body, the public body may take up a matter not on the agenda. Okay, and now I want to stress the word may first off, it's not obligatory like shall, it's may, so it's your decision. Further, state law says that your consideration by the motion that has already been made to open your agenda, if you will, and seconded, would require a unanimous vote of the members present and voting in order for the commission to hear the matter. That would be your first step. If that vote is not unanimous, then this case cannot proceed. What's interesting, though, in addition to what state law allows, is that, as you're aware, the Planning Commission has rules of procedure that are both codified in the parish code and to more minor points in its general rules. However, the code provisions and those rules are silent when it comes to opening the agenda for consideration of an additional matter, meaning it doesn't expressly allow for it, nor does it expressly prohibit it. So in my opinion, considering state law and considering the PC rules of procedure as they are currently written, it would be allowable or permissible from a legal standpoint for the commission to consider this matter. Just to go off on a tangent a little bit, the parish council does do off the floor, if you will, matters at their meetings from time to time. Some people would say every time they meet. But they are the parish governing authority and blah, blah, blah. But there is a written provision in their operating procedures that talk about how and when an off-the-floor item can be considered. And the council has to follow state law just like you do because it's a public body, of course. But it also adds the proviso via resolution of itself to guide itself that these items should be either an emergency or they should be a matter that is time sensitive or they should be a matter of the general public health, welfare, and safety as determined by it. And so if you wanted to consider taking action, you may want to consider being consistent with what the parish council does. But again, you are an independent public body. You are able to do as you deem appropriate under the circumstances. You also have a circumstance in your operations where most items that come before you must meet certain advertising requirements. However, and unless those advertising requirements are met, you can't even consider the matter. However, what's being proposed to you tonight, since it involves entering a parish right-of-way, basically entering a parish piece of property, it doesn't require any special advertising, short of what may be required under the opens meetings law. You know, typically an agenda of a public body can be amended up into 24 hours before your meeting, as long as it's posted. But in those circumstances where that allowance can't be met, then the opening of the agenda at the meeting is permitted, or opening off the floor, depending on what phrase you want to use. But again, state law does require that receives a unanimous vote to open the agenda before you even start considering the matter that has been brought to you.
Okay, does any commissioner have any questions for Mr. Savant? Mr. Willett?
So if we get the unanimous vote to move forward, this is just a recommendation to the council, so would it be on their agenda?
No, because entering the parish right-of-way is a matter that can be approved exclusively by the planning commission.
So this wouldn't even go to the
It-
next week's?
Ordinarily,
or
they
their
do
next
not,
meeting?
right, and
Okay.
ordinarily that you will see them on your consent calendar.
Right. Will it be on the
which-
consent calendar? It will be on the consent calendar, he said.
Well, no,
No?
it's put under old business, which is not part of consent calendar, but it
Okay.
we consider like a normal old business.
So it will be
issue-
on their
issue.
agenda?
If
we
the
go with
request
this?
was to enter the parish right away and it hasn't been approved already and a resolution
Oh,
hasn't
yeah.
drafted up, then it would be on the
But
consent
this, in
calendar.
this case,
But
wouldn't
this
if
would
it
be
moved
old
forward?
business.
Okay.
Yeah.
Bug, you have
Again, I think it's a good idea, but I would still like to hear, for my own satisfaction, we've heard the legal opinion, I'd like to hear from the staff if you guys have any problem at all with it.
No, we don't have any objection to it. I think Mrs. Casabon stated it clearly. It's just a technicality where that enter the parish right away was already
If-
approved under
if
the
I may have a
consent
point of order.
calendar.
yes, sir.
And this goes back to something Mr. Savant has said, and also go back to Robert rules. We cannot discuss this until such time that we open the agenda or open our docket to allow the case to be heard. The first order of business is that we must unanimously vote to even begin to ask questions or to engage discussion. Is that not correct, Mr. Savant? Okay, so the first order of business is that we must allow the agenda to be opened, then we can get into the discussion of the merits, not unlike something that is being postponed.
What did I just make my, that's
what I
what I thought I made my motion, was to put it on the, to listen.
But we haven't voted yet. We hadn't voted on this thing.
Okay, we had a motion
Discussion without voting.
and a second to open the agenda by Ms. Casabon, and who seconded it? Mr. Willie? All right, now it takes 100% to open the agenda. Please vote. All right, the vote is 9-0, so we have the 100% to open the agenda and hear Mr. Shane. Okay, now, I think we've heard Mr. Savant, we've heard Mr. Shane.
But I'd still like
Bug?
to hear from staff.
Bug,
I still would like,
okay. Well, we heard from Jay. Ron?
And I, after them, yeah.
I mean, that's not my area of expertise, and I defer to council, what they just indicated. We have no objections to it either.
Okay, and since it's sewage and water,
I'm not familiar with what it is, but if it's been previously approved, then I wouldn't have a problem with it.
okay. Mr. Shane?
Yes, sir. I appreciate the chance to say a few more things, maybe just in sum. I appreciate Mr. Savant's summary and other comments this evening. Again, if you wish to employ the criteria that the council uses, I don't disagree with Mr. Savant, you may, but I think Mr. Savant made it clear that, at least it's my opinion, that you are not bound by any rules amongst your body to apply any particular criteria in making the decision this evening. And in fact, I think you should take comfort that state law envisions that you have at least the right to determine whether or not you wish to open your agenda, and if so, take up a matter that I think has elements of emergency, and I didn't say dire emergency, but emergency, elements of health and safety, elements of convenience, and the critical nature of the timeline. Again, not to suggest that this is a hurricane coming out of the Gulf, steaming toward us at 100 miles an hour, but I think everything that I've talked about this evening incorporates those elements. So I would hope you would take that into consideration. And if you also believe that you would like us to appear on your agenda next month as well for a ratification, we will be happy to do that also.
Okay?
I do that by way of offer.
All right, Mr. Manella.
I would echo Mr. Shane's comments, given the fact that, and Mr. Savant's, first of all, this case was heard before the public prior to us addressing it at this time, so that if there was opposition, that would have given them at least an opportunity to do so. And I believe I'm correct in saying it has been extended, for which there was no opposition at the time of the extension. Given the fact that Mr. Shane, the facts that he brought in, it's been the experience of many public boards that when there is a technical error, especially when it may affect the public, when it may affect the cost of something, it would very much be in order for the governing entity to grant that. So those are just points of information from my perspective.
Thank you, Dave. Jimmy?
Yeah, I'd just like to say I appreciate Mr. Savant giving me the information that I needed to know, plus you will put on record. I'll make a motion to approve.
I'll second it.
A motion by Mr. Davis to approve.
Can we get dates in here too? So what it would be is you're approving for 6 months.
Be approving, and y'all correct me if I'm wrong, approving the extension of the resolution that expired on August the 11th.
Right.
Okay, and this would be for a 6-month extension.
6 to April 14th, 2015, to get the documentation to get a work order. And then the overall construction completion of that would be
2 years.
October 14th, 2016.
Now, that's one other thing I have a concern. Is it 2 years after the 6-month period?
No.
Or is it a total of 2 years?
It's a total of 2 years.
That's fine, that's fine.
Just a point of,
Mr. McDonough.
I also made a motion, in my motion that I made, that there would be no added expenses to this parish. That it would be all on, is that correct, if I'm correct?
If there are any expenses, we understand that we should absorb those. And I
Thank
might
you.
add, when I spoke with Mr. Magner earlier this afternoon, he indicated that when these matters are extended, they are extended from today's date, not the prior date.
Correct.
And that it resets, if you will, this 6-month, 24-month timeframe. Not that, gosh, I hope we don't need more than 6 months, but I probably would have told you that 6 months ago, and I'm standing here tonight, so.
Thank you.
Okay. Jay, so this would be extending the August the 11th resolution that expired, and it'd be 6 months from August the 11th,
No,
No, it'd
From-
be 6 months from now and 2 years from now.
yes,
6
from
months
this
now?
date,
Okay,
today.
And 2 months from now, and if there's been any changes in ordinances or anything, as far as how it's to be constructed and everything, that would apply to this project at this time.
What it would be, it'd be the ordinances that were in effect at the time this resolution was accepted and adopted or signed off. Just like our subdivision type things, if it gets preliminary approval at this certain time frame, then it falls in within like that warranty or any kind of developmental fees. So
But I can tell you that there are some items that we have extended previously, okay, that the extension is predicated on the ordinances that are in place the date that we extended, not what was in place 6 months, the year, 2 years prior.
well, you're extending an ordinance, or in this case, a resolution,
I don't
that
think
would
there's
have to
been any-
meet.
I don't think there's been any changes.
I don't think there's
but-
been any changes either, but how the typical protocol of it would be, at the time this resolution was accepted, it would have to meet those ordinances at that date. It wouldn't change to anything new that were set up after this resolution was accepted.
Okay, all right. Ms.
Because we're
Cat-
not doing a new one, we're just extending.
Right.
Yeah, okay. All right, Mr. Manella?
just a point of clarification, if staff could recite, or if Mr. Shane can recite what we're doing, what the resolution was, as if it was in the agenda, what the resolution is, the date it expired, the fact that if this commission does approve it, it would be in effect until April 14th, 2015, so that we have the public record. Thank you.
May I, Mr. Doherty?
Yes, Mr. Chairman.
May I? If I could suggest that if you are inclined to so move, that you would extend Resolution 12-055, which granted permission to enter the public right-of-way, Lindbergh Road, for the installation of a water line along the route, and as shown in the documents initially attached to Resolution 12055, which apparently the last extension expired as of August 11th of 2014. You would extend that resolution effective tonight, October 14th, for 6 months for the submission of all appropriate documentation for the developer and its contractor to enter the public right-of-way and perform the work, with the understanding that all work must be completed pursuant to plan specs and parish code, if you will, within 2 years of today, which would obviously, I guess, be maybe August 13, 2016 would be the last day to get the work done. October, rather. October 13 of 2016, I think, would be the last day of 2 years from today.
Okay, and in
So-
addition to that, then this would go on our agenda to ratify.
If you would like us to do so, that's fine. If you feel it's necessary, we don't request that, but I only offered that earlier. It seems to me like,
I don't really see it's necessary to do the ratification thing.
All right. What's the will of the commission? Do y'all
Call
want to
for
have
a
this
question.
ratified at the next month's meeting?
No, no.
Okay.
Call for question.
Is there any public comment? Okay, I see no public comment on this. Mr. Davis?
Yes, I'm ready to go ahead and finish this tonight.
Okay, all right. We have a motion and a second on the floor. Please vote. Motion carries. Thank you.
thank you for your time. I appreciate all of you staying later than you expected.
All right.
Thank you.
Anybody want to adjourn? All right, we have a motion to adjourn. Thank you all very much for staying and listening to this.
And I'll tell you this too, Dave.
What
Jay,
we've got here
I need to
is
see this.